Okay, we're live.
Okay, good morning. This is the Natural Resources and Energy coming back from the break. And we are taking a page 928, but we have some potential new language to look at from Mr. Chapman. Also, would love to hear from Ms. Lenz about fishing tournament stuff. So we'll do that in a minute. For now, welcome.
Thank you.
Yes.
For the record, Matt Chapman, Director of Waste Management Prevention Division in C. And so briefly here to speak about two things. One is an amendment that's before you, the other is just to note. So by understanding the other PFAS issue that is out there on the table are the set of 4 recommendations that the Attorney General's office put forward. I think that they understand the first of those 4 is probably controversial, the addition of the change and intentionally added, but the other 3 are technical and the agencies, so those changes.
And to be clear, they were attaching those 3, the
Right.
intent is to attach those 3 into 928.
That is accurate, and I would add they are what are probably oversights during the last sort of drafting of the consumer products law from a couple of years ago. So what I am here before you, one of the consumer products that was banned from use in the state were fluorinated containers. And Senator Hardy may have been on health and welfare when this happened.
I was, yeah.
And one of the things that just sort of backing away from this, part of the reason we had concerns around fluorinated containers were it you know, sort of the information that's coming about how some of the foreign coatings on those containers could leach into commercial chemical products. We set up a ban. I invited industry to provide me with information about why they might need an unavoidable use waiver. They didn't do so at the time. They have done so now. And basically there are certain use cases in the state of Vermont that I think are likely going to need to have a process for them to go through to obtain an unavoidable use waiver. I want to say this is a process statute, right? It allows for manufacturers to come to the Agency of Natural Resources to apply for one of these waivers to demonstrate that there are no alternatives to the use of a fluorinated container. And then there would be a notice and comment process and an appeals process associated with this. So it's frankly one of the reasons why I am personally comfortable with this coming in at the hour that it's coming in, because it's not, it doesn't actually exclude anyone from the ban. It gives them an escape hatch if they can demonstrate that they need it, and I think we're probably have it level as well. So that is, and I guess I'll say 2 other things. One is if it's effective, then you can't bring a consumer products claim against them. And I consulted with the Attorney General's office, and we're both swimming in the same direction on this. They are different.
Great.
So that's sort of the summary of it, and I'm happy to answer questions.
Okay, and do you have you submitted language?
It's on your website, and I.
Great, okay, and so we could potentially be including that as well into a new draft of 928.
That was the request, yes.
So it's,
Yes,
this, I'm looking at the language.
Sure.
Like, what's the universe of the number of people that might apply for this thing? I mean, are we talking like dozens, hundreds?
I don't think it's hundreds. I mean, I think really what we're looking at is the areas that I'm most concerned about are just like precision manufacturing, things like
Okay,
semiconductor
so
manufacturing.
it's a small subset.
Yeah, I think so.
Okay,
You know, but I didn't want to cabin us in either, because there may be things happening out there that I don't know about, and I think it's the door if there's a good, so.
okay, thank you.
yes, good
Question, 2 questions, Matt.
Yeah.
One, when this type of thing generally happens, where you do an unavoidable use waiver, they're not indefinite, are
No,
they're
they're-
time.
I thank you for bringing that up, Senator. These are time bound. They cannot be for any more than 10 years. And the
Okay.
agency can make them shorter than that.
Okay. Okay, because basically this is supposed to, in a lot of ways, be a bridge until there's an alternative that doesn't include the toxic chemical.
Correct. I will say, in the interim between the time we took testimony in health and welfare to today,
Yeah,
there's much better information around the
Yeah.
regulatory regime. I mean, I have, there's generally available information on the regulatory regime. The Florida containers basically get used in large part because of an international sort of agreement around shipping containers and what sort of standards they need to meet to make sure that chemical products don't leach through them when they're in transit
Yeah.
and don't explode if there's some sort of accident, right?
right,
So there's both a framework internationally for how they get managed and then a very detailed process for how you go through and get an alternate type of container approved.
Mhm.
So it takes about 10 years to do that.
Yeah.
Which is why having a 10-year makes sense, though it could be narrower. I know industry is looking for alternatives to chlorinating the inside of containers for
Yeah.
commercial chemical products. My understanding is it's difficult to maintain the purity of the product and the stability of the container.
Yeah. It's like this web of complex things that we have all created. But then also this language, I'm assuming is, because I know this kind of waiver language exists for other products, yes? Or I
So
think it does.
there are other jurisdictions that are using the
Okay.
same way.
Okay, so this is.
It's similar to what Maine and Minnesota are using.
Okay.
Now, I do, are any other questions for Mr. Chairman? I do want to, Mr. Burns, if you want to weigh in at all on this, let's give you the opportunity, or you could do it tomorrow. I mean, whatever.
Happy.
Yeah, sure.
Thank you, Madam Chair. For the record, Paul Burns, Executive Director of Beacon. So a couple of comments on this. One, it is May 7th, and I just saw the language in the last 24 hours. And I know Mr. Chapman described that there has now been a request for this, the request that wasn't made earlier on, and Mr. Chapman, to his credit, did a lot to provide opportunity as this legislation was being considered. So it strikes me as very late, obviously, in the session, and while there's a suggestion that there's a lot more information out there, we haven't been looking at that. We haven't had an opportunity to talk to some national experts that we would prefer to. I mean, if we're going to make this exemption, we would prefer to have an opportunity to really do it the right way, to investigate and try to, make contact with people who frankly have greater expertise in this than I do. So that's one thing, and the reason why I think perhaps you could wait is, unless I'm mistaken, I think this section doesn't take effect until 2032.
There are two effective dates.
30 and 32, is that
I think that's right.
In either case, it would seem that there might be time in the next biennium to consider a change like this before it takes effect. So that's my suggestion, really more on process than on substance. With respect to substance, I'm not suggesting that we would never go along with a proposal. This may make sense, maybe a reasonable thing. We wouldn't have necessarily opposed if it came up initially, as part of the conversation. If it is just a question of justification, is a little bit uncertain to me right now, because we really haven't had a chance to dig in this, because I would defer. And if you were to go forward with it, I think I would say 10 years is quite a long period of time. Mr. Chapman just addressed that, but it strikes me that 5, particularly for a section that takes effect either in 2030 or 2032, another 5-year extension is really looking quite a ways out into the future, and that might be sufficient if you felt that you needed to move something quickly. No, I think that's the extent of my comments right now. I appreciate that.
I'm sorry, can you say that last part again?
This section of law, there are two provisions. Again, if I'm remembering correctly, 2030 and 2032, it takes effect. That is the prohibition of PFAS in these fluorinated containers. If you're granting this waiver or extension, that's another 10 years. If I'm understanding, up to 10 years, the agency has discretion to make it a shorter period of time, but perhaps up to 2040 or 2042, if I'm understanding this correctly. That seems like a very long time in the future to be doing it on the fly right now. So
Well, and I'm wondering, I guess I wasn't seeing the 2032 in here, is that,
You wouldn't, it's in the underlying
oh,
ban itself, so it's in Title IX and the section it's referenced.
nice.
Yeah.
Let's see.
And part of, I will just note, part of the challenge is, so all of the consumer products bans are housed within the Consumer Protection Act, which is administered by the Attorney General's office.
Mhm.
We're now in the science part of things, which is really the Agency of Natural Resources. So the AG's office and I collaborated on an approach that's basically the one you see before you, where we're doing the science and it gives someone a waiver from this.
Yes, ma'am.
I like this language, and I hear Mr. Burns' point, but I think industry also needs some certainty too. Of where they're going to, you know, grow their companies, put in new machinery, put in new equipment. And I think, you know, by putting this decision off, I think we invoke a lot of uncertainty into those types of decisions that would really be good for Vermonters and Vermont's economy. So I'm a supporter of doing some certainty right now.
Thoughts?
I'm fine with this. I think it's narrow and this is it's only after they determine that there's no alternative. And I think they are trying to find an alternative. So maybe by the time this is relevant, there will be an alternative and we won't have to issue them. But I'm okay with this.
Any thoughts in the comments? Okay, that's fine. So one thought is that, because I'm also valuing what you're saying, and thinking about how the clock could potentially go both ways, sort of like what do we want to default? Like if you vet this with folks and comes up that like this process has changed or it's a bad idea, then we could all always revisit it. Future year. Okay. So what I'm hearing from you all is that we ought to include this in the next draft. And by the way, we were never intending to vote this out today. So it's gonna be tomorrow. So but we're expecting this already soon. So we'll see. Thank you so much.
Thank you.
Okay, we're gonna go now to Ms. Lenz. Yay, welcome.
Thank you.
Yeah.
For the record, Maggie Lenz here on behalf of the city of Mary today. So we do appreciate, excuse me. We do appreciate, so come to the table and try to find a path forward on this language. I mean, as a reminder,
Fishing tournaments.
the fishing tournaments,
Yes.
I'm sorry,
Yes.
this is where my brain is.
Yes.
To everyone else in the housing, my brain. The fishing tournament.
Yeah.
Is this on our website?
It's in the latest draft of 9/28.
It is, but it's a little unrecognizable as what we first discussed.
Oh, okay. It's not on our website.
Because it should be.
Probably somewhere. It's not up there.
Sorry, Maggie, I just want to make sure.
That would be draft 3.1.
Of the
9/28,
fish and wildlife?
Yes, yes, the official number bill, so, we ended up, I don't know if you remember, we had, Mr. Redmond in the drinking water division, he was like, we have suggested language.
I only have, wait, 3.1?
Yes.
Oh, yes,
Yes.
I didn't have a smiling face.
There you
I don't know
go.
why.
Right here. Free.
It's page 3, subdivision 3.
Line 7.
Yes, listen.
Okay.
So it's best management practices language. And so this is a significant departure from what the city of Barry was looking for initially. That's probably no surprise to you. What Barry really wanted, because of past circumstances surrounding permitting the fishing tournaments on Dick's Reservoir, which they own all the land around. They really wanted the municipal governing body to have the authority, not a blank check to say no, but the authority to vote on these permits. Because they were being issued, the city was finding out about them after the fact. And they were trespassing people at great cost to the city. They were told at one point by Fish and Wildlife that the permits were going to continue to be issued because theoretically someone could parachute onto the water and not go over city limits. So this is the genesis of what we want. What we have here, and I know, and I think it really is a good faith effort in trying to path forward, because I know this has been difficult. But this is best management practices and it really doesn't get to where we needed it to go. There's a couple concerns, so, it seems to, in my estimation, it makes me a little worried because the best management practices, there's language that says best management practices shall be designed to mitigate any potential impact of a fishing tournament on public water systems. And I know I've spoken with Mr. Covey, we read this differently, but very cautious about this. This makes me concerned that mitigation practices may be defined after a permit's issued, and then this would go on to the municipality. Or the best management practices will be defined. This will include steps to mitigate that will go onto the municipality, onto the city, onto the water treatment plant, and then that's going to be a condition of a permit, would be the city's, so to mitigate further. So in the spirit of compromise, I think we can support a similar framework. We would really feel strongly that if this is gonna move forward, that it be coupled with the bill back provision that was in an earlier draft, which would give the municipality the authority to move costs associated with trespassing mitigation over to the tournament ordinance.
Do you don't have language to suggest, to outline that?
Well, we like the bill back language.
Oh, that was in there.
Yeah,
Yeah. Okay.
yeah.
And I think I'm gonna jump to either Commissioner Batchelor or Ms. Smith about that. I don't know if you have comments about the build act language that was in the original draft. I think, if I recall, there was some concerns about that, but do you, if you.
I'm happy to speak to that
Okay.
now. Jason Batchelor, Fish and Wildlife Commissioner, for the record. I feel the original language put too much undue burden on a tournament organizer who might be just a gal or just a guy off the street trying to do well by their community and issue a trophy to a 10-year-old. I really can't get past the fact that we're in 2026 and have had 0 incidences of problems with anglers being on lakes, and to point at a group of individuals as special simply because they hold a tournament permit from the department, I think is unreasonable. I think if, as I've used this example in the past, if a handful of folks want to have a tournament, they're subject to this rule. If 100 people wanted to go fishing and didn't have a tournament permit, they would not be subject to this rule. I don't see this as a reasonable place to land when we work so closely with DEC to try to mitigate. Well, the proposed language says we will, and I am here to say we will. We're quite chummy, and I am very excited to work on this permit in a way that pleases the committee and the city of Barry. I hope that sounds sincere. It is sincere, and I don't want folks to worry about something that in this day and age it simply is something not to worry about. I don't know how else to put it.
Thank you. One, just to put it out there, as a part of the best management practices that we're not expecting people to parachute into waters.
We're not.
Put that out there. So one possibility is that we leave this in here. Another possibility is that we take the whole thing out and just try to address it in a future year. I'm curious for the thoughts from the committee around the build back language. Maybe we should start there. Any thoughts about this one? Like adding it back in? Where is that again? So, oh gosh, is that 221?
It's probably the most current version that's 224 or
What do you?
Oh, there we go. What do you? Well, so there was. Oh my gosh.
Ages ago.
It's so
Yeah,
long
it's a long
ago.
time ago. But we had. I'm trying to remember mine. The most,
Yeah, it's
had draft.
10.1.
That tells you, not quite 17.
Where is
This, it's online, 10.1.
Yeah.
Under our community.
Yeah, if you- it is from March 13th.
And it looks like there's, the provision is on page 24. At the bottom, subdivision 2. Commissioner,
Okay, I'm caught up now, but I need the page number.
oh, page 24.
Since, even so long.
No,
I think it's D
that's,
sub 2.
yeah.
We're in kind of line 18.
Oh,
If the commissioner approves a fishing tournament on an inland lake. Serves both the drinking water source municipality applicant, tournament shall reimburse the municipality for costs incurred.
Here's my add that the land is owned by the municipality, because that's not.
Oh, if the land is on it.
I mean, by the way, that's written, but just imagine the interest of narrowing.
Yeah. Before we go, Senator Palmer, is anything you needed from us?
So we're just making sure Senator Williams.
Okay, yes, yes,
Yeah.
very good, thank you.
Thank
Yep. Thoughts about adding in this provision about charging?
I would rather not.
You'd
I
rather,
want it out.
well,
Take it
so
out.
that's Senator Williams?
I'd like you to take that out.
Oh, to not include that, okay. Other thoughts?
Wondering.
Yeah.
Word to, I wonder if chief language shall, the best management practices shall be designed. Something about to ensure that the permit mitigates any potential impact on the drinking water system. And that there is no undue cost to a municipality or something like that, so it's just not, yeah, that it's sort of making it clear that the municipality is not gonna have more financial burden, and that the permittee has to do things to make sure, you know, they're not leaving their lead lures in the water or whatever.
Right.
Although I think those are not allowed anymore. I was just trying to comment.
Yeah.
So here.
Yep.
So the language in 3.1 says, designed to mitigate any potential impact.
Yeah, and I think the concern that I'm hearing from Ms. Lenz is that that would shift the burden and the cost onto the municipality, and they would have to mitigate the impact, so if I'm gonna come, I don't know, if there's like fuel left in the water from boats from a fishing tournament, that the city, the municipality would have to pay to clean it up in order to mitigate the impact on drinking water. And so I think that's a legit concern to say, okay, well, the mitigation needs to be on the permittee, not the
Yeah, I agree with that.
municipality.
Where I was, you know, when we say any potential impact,
Yeah, that's.
and then we start listing, then we're kind of almost like, I don't, you know. If we say any, and then we say one, do we have to say all the potential impacts?
Oh, no, I wasn't suggesting list
Oh.
anything, but I mean.
I'm just looking at the language of 3.1, I was kind of.
And also, I think we have to remember that this is language to create guidelines, and the guidelines will have the specifics, so this is just trying to get. direction to the two departments.
Protect municipality.
Yeah,
Yeah, and the water, I mean, that people are drinking.
I wonder if we could add a line, some, like a sentence about intent. That it's the intent to preserve the quality of water and to insulate municipalities from additional costs.
Yeah,
Okay,
yeah, open stuff, sure.
okay.
Just kind of a rewrite.
Just looking at it.
Yes, I think that would be, this would be a Bradley,
Can I put a smile on face?
I'm gonna just write in here that we're gonna add an intent section. And just checking in with Fish and Wildlife folks, intent is okay, yes?
Yeah, and for the record, this is Hannah Smith with Fish and Wildlife, and that's fine, but the permittee, the fishing tournament organizer. Is responsible for complying with conditions of the permit, and I don't think that this could be interpreted to, I mean, we would never hold a municipality responsible for not complying with the fishing tournament permitting requirements.
Great,
But yeah, intent is fine, that's our intent.
great, just we'll keep it super clear,
Yeah.
okay, thank you.
Thank you.
Okay, so with that, I will pass that along to Mr. Schulman, and we'll get a new draft for tomorrow about that, thank you.
I appreciate it.
Okay, so we are gonna move now to Mr. O'Grady, and we're still on 9:20, I believe, because I think we need to look at some new language. And we have to, well, I'll just say we have to cook. So is that not what you have? Do we have the language from you?
Did Bradley send you, the new draft in 9/28?
I'm not sure with PFAS.
Yeah, 4/24/2026.
Is it 3.1? No, before.
So 4.1 that I have.
Claims check, see. Okay. Jude, I'm gonna forward this to you. Thank you. Yep, and actually, I'm gonna just forward it to everybody. Okay. Jude before, okay, so Jude, you have it. And I've just forwarded it to everybody. Okay, if we look at it digitally. Okay. It might take a few seconds here. Okay. Do you folks have, okay. Okay. Mr. Grady, go ahead.
Okay. Let me just be clear, you're looking at what? Draft 3.1,
4 point.
that's on your committee webpage?
I'm just putting it on now because I just got it.
Oh, right, in your email.
Yep.
Alright, so draft 4.1, page 2. In the 6th instance of amendment. We're talking about the regulation of PFAS, as you probably all recall. Over the past several years, you've started to regulate PFAS in certain consumer products. And you've done it relatively specific to the type of product. Cosmetic or menstrual products, food packaging, firefighting, etc. And in so doing, when you have done it, and it's been several drafters that have been drafting that language. There hasn't been total uniformity within some of the chapters. And so the Attorney General is looking for more uniformity across some of those chapters. And making sure that they have all of the, either the same standards or the same enforcement authority across all those chapters. So that they can effectively implement all of the PFAS laws for PFAS and comments. And so that's what these three instances of amendment do. In the sixth instance of amendment, you are basically adding a new section 5, which is amending or adding 9 VSA 2494D. This is one of the tools that the Attorney General uses to ensure compliance by industry with the PFAS laws. The Attorney General can ask the person that's subject to the law for a certificate of compliance that they are compliant with the law. That person can provide that certificate within 60 days, or they can notify the persons that are selling the product of the manufacturers that it is prohibited and that product needs to be removed from sale. And then the manufacturer can submit, or when they submit a certificate of compliance, they can rely on a certificate of compliance from a subcontractor, someone, a supplier that is supplying them, so that they say, AG says, hey, cosmetic manufacturer, are you complying? Cosmetic manufacturer goes to your supplier, give me a certificate of compliance that what you're providing me is PFAS free. Supplier provides it. Cosmetic manufacturer provides the AG, but certificate of compliance, including the supplier's certificate of compliance. And that is a tool that is used in firefighting, food packaging. It's in most of the other chapters where PFAS is being regulated, PFAS and consumer product. It's not in the cosmetic and industrial products chapter, and that's what the Attorney General is looking for, and that's what that section 5 of page 2 to 3 do. Similarly, section 6, page 19, line 19, page 3, line 19. You're now in the food packaging chapter, PFAS in food packaging. Most PFAS chapters and the requirements for them apply to the manufacturer of the product. This chapter does not have a definition of manufacturer. And so the AG is asking for the definition of manufacturer to be added. This is the same definition of manufacturer that's used in the other PFAS chapters. So it will be consistent for purposes of the Attorney General's implementation. And then last, on page 5, line 10, section 7, this is about the selling of used products. The PFAS regulations do not apply to the selling of used products because, frankly, they're in the stream of commerce already. To determine whether or not they have PFAS and how to regulate that is practically impossible. So this page 5, 911, this is in the food packaging chapter. It's conforming the used packaging or used product exception to the used product exception in the other chapter. This section shall not apply to the sale, offer for sale, distribution for sale, or distribution for use of food packaging previously used by a consumer for the intended purpose of the product. So all your Tupperware out there that you got from your grandmother, you don't need to throw. Sure. And you can sell it.
You can stop. Okay, great. Questions, concerns, thoughts? Okay, so that is it for 928. And I think everybody has agreed on that language. So I think we can move on, which is great. I'd actually like to move to H 727, not 915. because I think that's actually gonna be a more compact conversation. Bottle bill, maybe slightly less compact. So just to get it out of the way, so we are still looking at, getting back to
Same draft.
same draft from earlier,
Hey, that's on the what's.
yeah.
So we were putting this together this morning, and I left without having this recent version is
This was starting on page 11. Or at least that's when the section starts.
Yep. Section 3, page 11. This is the section related to water use, cooling, and permitting quality. Do you want me to just look at the changes?
Yep.
So we did not change the closed loop cooling system. Did not change the definition of PFAS. In the requirement to use closed loop on page 12, line 19, if water is used to cool a data center, the data center shall use a closed loop cooling system or an alternative cooling system approved by the district commission to minimize impacts to quality and quantity of surface water and groundwater. Before approving that alternative system, the commission shall find that the alternative cooling system will minimize groundwater use or surface water use and will not unreasonably burden the public water supply, surface water, or groundwater use. That work?
Yes.
And then there's reference to the alternative cooling system. If water is used to cool a data center through a closed loop cooling system, through an alternative cooling system, the data center shall identify where it will obtain water, so where the water will be distributed.
So, and just to be clear, we're still trying to minimize the impacts of, to the quality and quantity of surface water.
Yeah,
So, cause the phrase that we've been talking about was like using a de minimis amount of water, or like, but you feel like that is captured.
well, I went and I looked at a couple of different standards in current state law and other data centers, and the unreasonable burden on is really that's kind of consistent with the Vermont groundwater strategy. And it's consistent with how other data centers have been regulating.
I don't have it. It's a lot, but it's.
Oh, it's 1.4.
I just did it.
We also probably,
Now we came back in, it's still found.
did you refresh them? Here's a draft for you. If you want a hard copy, it's good. Yep, and it's,
Up there.
yeah, it's we're now on page 12. 12.
And instead of the minimus, it says that they have to minimize groundwater or surface water use. So that would be something the district commission will evaluate for purposes of approving that alternative system.
Are you finding that significant?
Probably kind of, the one thing I had been thinking about, I don't know if it's makes sense or not. Is that it wouldn't reach more than a closed loop system. So that would say, on alternative that is.
I mean, I think you could add that phrase on line 13 on for approving an alternative cooling system. District commission shall find that the alternative system shall not use more water than the same scale for the closed loop system, because it would be required for I'll have to work. No, yeah.
And make it and.
Right, and don't minimize groundwater use or surface water use, and will not unduly burden public water, so that's just water.
Yeah, I like it. That sounds good to me. So we'll look at that for a new draft, okay. Okay.
Then you can move to the bottom of that section, and it's the end with PFAS, which. Oh, wait. This is in the previous 401 language where it said that. If you're gonna be using water that you're gonna have to do a 401 instead of 401, you're sussing out that specific assessments that you wanna do. So if the data center proposes to use more than 300 gallons a day of surface water for cooling, the agency will do the application for a surface water withdrawal permit. If they're not available yet, shall assess the impacts on water quality, product biota, stated in nature and threatened species. And stream flow habitat, impingement, stream back erosion, coral habitat, but what do you not see there?
401.
Shorelands.
Oh, shorelands, okay, yes.
And that's because, as the chair pointed out, when you go to the shorelands permit section, something that receives an Act 250 permit doesn't need a shorelands permit. So this is an Act 250 permit. So if you get this, you don't need shoreline, so you don't need to do a shoreline. You don't need to reference it here.
Okay.
If you never pointed that out. Great call. Page 14, line 9. The issuance of a surface water withdrawal permit by the agency after completion of the assessments required under 2A shall create a rebuttable presumption that the data centers will not result in undue water pollution due to the requirements of subdivision 68(6)(a)(1), that's criterion 1. So if they get those permits, rebuttable presumption that they're not gonna have undue water pollution. And then the agency may by rule reduce the amount of surface water proposed for withdrawal by a data center, which the agency will be required to complete the assessment under subdivision today. Remember, surface water withdrawal permits haven't been issued yet. You don't know if 300,000 gallons a day is what A&R is going to come up with as the necessary jurisdictional trigger for anything, let alone a data center. So you want to build in some flexibility that in the future, A&R can change that 300,000 trigger, depending on the surface water program.
Okay.
And then, page 14, going on to page 15, this is the PFAS thing. So this is new, and I don't think you've discussed it in great detail, but a data center that discharges waste. And waste is what you discharge in Vermont that triggers the permit, so that's why it says waste. Shall monitor for the maximum number of PFAS that are detectable under U.S. Environmental Protection Agency standard methods. So there are 2 standard methods. One that's specific to 45 to 50, one that's specific to fluorinated compounds. So they will monitor for the maximum number, they'll enter an agreement with A&R on it. And then the data center shall not discharge waste that exceeds the criteria established under the Vermont water quality standards. So if they're discharging and there is going to be a PFAS standard in the water quality standard, hopefully within my lifetime, then they will have to meet that. But if no criteria is established under the water quality standards for PFAS, the data center shall not discharge waste above the reporting limit of the U.S. Environmental Protection Agency standard method utilized to monitor for PFAS in surface water. So if you're below the monitoring threshold, you will be compliant. So because it wouldn't be detectable. Right, but if you're above, then it's detectable and you are in violation.
Yes. What about the thing, the issue that I brought up before about if the EPA water standards are obliterated, do we need to put a little marker and timestamp?
So these aren't the standards, these are the monitoring assessments, they're just the tools, and I could just say the monitoring. The standard methods available as of January 1, 2026.
Yeah. Yes. Sorry for the paranoia, but that seems, it's not fair. Someday there are two points, I think.
So. Yeah, I see what you're saying.
Yeah.
Yeah.
Because.
Yes, go ahead.
Going back to this discussion, I see the order of the agency use the amount of service protocol. For the assessment, but if we were such at the fact, 300,000 gallons comes from open system.
Yes.
We're talking about flows, why was about, you know,
Really.
I didn't do that.
Thank you, I forgot about it.
and,
Well, we're gonna get a new draft anyway,
okay,
so.
well, sure it's. Depending on the stream, 300,000 gallons, that's a lot. And yeah, the sources.
Yeah. Where is this at?
It's on top
So,
14.
page 14, I was supposed to look into what the average or.
River, it's nothing, yeah.
Yeah.
Yeah. So.
Okay, well,
Smaller.
so we'll flag that for the draft tomorrow.
And just, I mean, I could probably pick this out, but just remind me. What are we doing about groundwater, which is what we're doing?
Groundwater already has a permit for everything. You are saying on. Page 13, line 9, if the data center proposes to use groundwater, they have to get a groundwater withdrawal permit. Regardless of whether or not they're withdrawing more than 57 sets a day or not. And so then there's a whole rule and a strategy, and there's a public trust analysis that needs to be done to ensure that there's no damage underneath the groundwater strategy to other uses dependent on groundwater.
Okay. Senator Williams.
What if it's river water?
Well, that's surface water. That's the one that we're talking about where I have to go and look at what the appropriate volume is for closed loop systems. They haven't issued that surface water withdrawal permit yet. That's probably not going to be available until 2027. But once they do, they can adjust that, and that's the flexibility for them to adjust that is on page 14, line 14. They may reduce the amount that triggers that analysis at a future date, but they would have to do it by ruling.
Okay, thank you, that's, appreciate the thumbs up. Super. Okay, I think that is,
One last thing.
yes, oh, okay.
So I wasn't sure, page 15, line 6 and 7. The language in F, in my opinion, kind of consumes the language that was in your previous sub G, where data center is prohibited from adding PFAS any discharge. You're basically saying that what the standard is going to be for the discharge in F, and I just wanted to run that by you. You're aware
Mhm.
that that's going to change.
Yeah, I think that is practical, so. Okay, great. Thank you so much. So we'll look for a new draft on that with a few changes.
Yep.
So down to 727 for now. Now we're gonna move on. Into, yeah, H915, Bottleville. Bunch of drinks. Okay, so this is. I think, so, because we got 4.3 yesterday, but we ended up not walking through it. Sure thing. Right. Oh, wait, oh, this is, but this is, wait a minute, this is timestamp 5.
Yeah, I made a change this morning based on some input that came in over.
Oh, okay, so I'm gonna not. Okay. We're gonna go with this draft that just got passed down.
Yeah.
Okay, I'll turn it over to you to walk through this and then about to have some conversation. Mr. Driscoll, do you have something on 727 or on volatile?
727, so it's question whether you want me to address that now or tomorrow.
Let's go with tomorrow.
Okay.
Is that okay?
Perfectly fine.
Well,
Is it fast?
yeah, if it's fast, yeah.
I think it's fast, but,
Tomorrow is kind of,
Yeah.
updated, so.
okay, so you
Yeah.
can stop me if I, so Builders Association of Vermont with regard to, PFAS, level restrictions. So with regard to the first part of that, I think we're fine. There's some concerns about the monitoring focus, but certainly acceptable up until page 15, after quality standards, when you go to if no criteria is established under the plan. So the problem with that language there is, and I talked to A&R about how they interpret this. That would be no detectable PFAS would be allowed at all. So the concern with the previous language was that you would be prohibiting any added PFAS regardless of where it came from, or regardless of whether it met any health or safety standards. This language does the same thing, but even worse. So in other words, you could have water coming out of a plant that's lower than PFAS. Then it comes in, but if it's still detectable, you have to stop. So that's the policy problem. As a practical, I would hope reassurance, folks, is also my understanding that despite Mr. O'Grady's inherent pessimism, the agency, I believe, is confident that they should have fairly comprehensive water quality standards for surface discharge within a couple of years. So I think that to the extent there's a gap in Vermont law, that should be filling fairly soon, but in the meantime, this would be a very concerning precedent to have on the books, and also if there is a delay in water quality standards, this is even more concerning than the previous language, because it could be an issue even if there's less PFAS. So I think it would be cleaner and hopefully still get the same place in the end and avoid precedents and concerns, and simply end F on line 1, make sure to get factor quality standards and focus on the Vermont regulations.
So,
So ending,
14.
yeah,
Bottom of 14.
So it's actually, what's
So-
the suggestion?
so you're saying strike out the sentence that starts, if no criteria has
Yes.
been established.
Yeah.
They shall not discharge waste above the reporting limit. Of the law. Though to be fair, this is likely only effectual language for the next till 27, when the withdrawal permit comes out.
Well, I would hope this would be effectively limited once Vermont has comprehensive water quality standards, which, yeah, but in the meantime, this kind of standard would be, again, very difficult if not impossible to meet. It's very arbitrary in what it would be prohibiting. Again, as I said, it's regardless of whether it was a health concern or whether it's increased or decreased. It'd just be bad.
It's not there.
This withdrawal.
Yeah, it's not sure, not
The
tied to
ones that
2027. It's tied to the water quality standards, and they go through a triennial review. I've heard that there may be a PFAS standard to address human health in the next triennial review. It won't be a traditional surface water quality standard, but there's the potential in the next triennial review. I don't know.
Is that what you were gonna say, Mr. Grogan?
Not exactly.
Oh,
but
sorry,
yeah.
I also don't want to interrupt Mr. Grady if you were not done.
No, I mean, I'm done. I just wanna also
Yeah,
just
okay.
caveat triennial review, sometimes it's. Quadrennial.
Yeah. That's fair. Okay, yes, go ahead.
For the record, John Roman, Mount Alfred with the council.
So I mean, I've seen Trino reviews go on for like 6 years or more, so I do not think we could hitch our wagon to the creation of a standard that has been difficult to create. And I think it would really be a big mistake just to leave this gap in the law during that period of time. I don't know what Mr. Driscoll was talking about. If you look up the reporting levels, it's not, I don't know what no detectable standard means. They range from like the 0 to like 10, I think, parts per trillion of PFAS. It depends upon the PFAS compounds. And I would submit that if industry and the agency don't like that, this will motivate them to create a standard. If you do not do this, we will have no standard if a data center comes in, and there'll be no motivation to do it. If people really don't like this standard, which is, it's something you can actually implement and monitor for, which is why this change was made in response to Mr. Driscoll's concern. And I would submit there is no way to address Mr. Driscoll's concern. He just doesn't want a standard, until the agency proposes one. And I could imagine when that gets proposed, there'll be arguments about whether that standard is the right standard or not, whether we should have it at that level. So we could just keep arguing about what the standard should be and have no standard, or go with what EPA in their pretty conservative methodology has put out there. This was not something that's put out, willy-nilly. It was developed over a long period of time, and it could be used to determine how much PFAS you have in your wastewater, and then you have to meet that standard. And again, if people aren't comfortable with that, let's motivate and create a Vermont-based standard, but just don't leave it. If you leave it blank, it will be blank. We'll have no regulation of PFAS being discharged.
I want to check in with the committee, your thoughts. Sorry, yes, go ahead.
I'm comfortable with the language that's in here. I have a question about an S. On line 4 on page 15. The method. On line 20 on the previous page, you had methods, and now it's singular, so I don't know if it's supposed to be singular or plural. Or if there's a difference in these two.
I mean, like. We can go.
Sorry, Michael.
Under Title I, singular is plural, and plural is singular.
Oh, cool.
But I do think, for purposes here, you're talking about only 2 different methods, so I will change it to methods.
Okay, I just thought consistency, but I like that. I don't want to.
Other thoughts? This is. I am also inclined to keep this for now, but I'd like to keep having a conversation about it, so happy to connect later, because we gotta keep going, so. To be continued, let's keep it for now. Okay, so I think we're done, again, with 727. Bottle bill,
Okay.
okay.
Draft.
That's not a sign at all.
Draft 4.3, May 7/26 AM. I'm gonna step through the changes. Is that what you would like?
Yes.
All right, page 2. Line 17. There are a couple of instances of language where Matt and I kind of default to like EPR terminology, and so he'll say stewardship organization or point of collection. And so it's point of redemption.
Yes.
It should be.
Oh.
Standard producer responsibility.
Okay, got it. Okay.
So that you'll see a couple of changes where our brains kind of intuitively use certain terms which we should not be using in this stuff. So
Point
page
redemption.
2, line 17 collections and reduction. And then next is page 6. This relates to something that Senator Beck had raised, and that is an issue that I've heard about in other bottle bill states. It's the redemption center, the retailer refusing to pay the full value of the deposit for the return container. And which is against the law. But this language would very clearly say page 6. And a retailer or redemption center shall not refuse to pay a person the refund value of the beverage container established under the section 15. There's a Massachusetts redemption center that is not paying the full value. And say,
Too bad.
Does this also prevent them from paying more than the deposit value?
yeah, that is, the deposit value is the deposit value
And that's what you pay, period.
you pay, period, to the person returning. Now, when you get into the plan and you're talking about their compensation to the redemption center and the retailer, that could be subject to negotiation. Remember, the handling fee is gonna be.
The difference between the PRO.
Right, that'll not, right. Yeah. All right, I do think there needs to be a technical amendment on page 6, line 18. Where it says except as provided in subsection D, it should be subsection D or C. And that's been in there for a while. The next change is on page 9. And this relates to testimony that Comra provided you regarding the requirements for liquor redemption. On page 9, line 7. It had previously said retail redemption, but liquor bottles are going to be redeemed by redemption centers and retailers. And so Comra's point was this has to be conformed so that it reads that it applies to both the retailer and the redemption center. So a retailer shall not refuse to accept the beverage containers that they, well, that's fine. But then DLL shall not refuse to pick up empty beverage containers subject to the section, pay the refund value, pay the handling fee to a retailer or redemption center. It had previously just said retailer. So this is no longer just about retail redemptions, but redemption as a whole. The next change is on page 16, and this is the A&R, what I call it A&R big or bigger-ish. It's page 16 when they issue their own plan and they have that assessment on top of the cost of the plan that had previously been 10%. You wanted that to go up to 25%, and that's the change that's made on page 16. Should I move on?
Yep.
Next change is page 18. This is clarifying the language in the convenience requirement for 7 towns of 7,000 or more. There, it had previously said on page 18, line 12 and 13, unless the secretary waives the requirement, and wasn't sure what was waiving, the requirement for the 7,000 collection or just the immediate return. And it's the waiver of the immediate return unless the secretary waives the requirement for immediate return.
Thanks for making it clear.
Okay, moving on, page 19. This is another Comra request. You may recall from prior draft that the PRO was prohibited from using single feed reverse vending machine or mobile points of redemption to meet the convenience requirements in 3 points of collection per county. Comra's point is that it should be, may not only use single feed redemption. So maybe if you're at a redemption center and there's single feed there, but there's also manual redemption there. So the way that it previously was drafted, you could argue that single feed wouldn't have been allowed to meet that. So you only have 3. Redemption center has maybe, does certain numbers of hours of manual collection, but also has single feed there for after hours. Would you want to prohibit the single feed in meeting the convenience collection requirement in that instance?
So we want to allow that to.
Yeah, and that's what that does. They may not use only single feed. And probably should say may not use only mobile points of redemption. The Tom didn't request that, but it probably
Mhm.
should say,
Or only online 7.
yeah.
Yes, go ahead.
Just thinking, going back to page 18, thinking about the Western Circulatory waves. If we think it's important that the B of one of the three have immediate return. We want to put, I mean, this is Western Circulatory waves as well.
But this is only in the 7,000 pounds. Right, so in the 3 per county, at least one still would have to provide immediate return.
And it's 7,000 down, that's where you're going to return. I don't want to, it's not things to all electricity. So gonna be pressure on the secretary to do this. And therefore, it'll be clear. That the exception will swallow the rule, suicide.
And maybe, maybe bag drop is gonna work better in some towns. No, where you're not gonna get that immediate return, you're just gonna get an auto cost show on your app. But you won't have to cash in hand.
I'm just thinking of, it's part of the way here is for people who don't have it.
Right, right, and we need the money,
Yeah,
we need the cash.
maybe it's not.
Does your concern just getting rid of the authority to waive?
Well, I'm actually just thinking out loud, I'm not sure what I actually should flag it as something that. If we need it, then we don't wanna make it easy to waive. It's also not the biggest difference, but it's very,
Yeah,
I don't know, I mean, I flagged this just because it was unclear what the secretary was waiving, so,
yeah.
but, that's a good point, I mean.
Let's leave it for now. And if it's always easier to remove than to add. Mr. Switzer, do you have something to say about it?
Just a thought about that, it gives the PRO flexibility in those towns to be able to waive it if they need to. Or, if they could see what you're saying for sure, but at the end of the day, it gives them a little flexibility there. So they don't have to stand up a redemption center if it's not feasible, like Michael mentioned about, maybe it makes sense in certain places, but not on development. Just think about
Yes. Okay, happy to revisit it also. Okay,
Okay, on page 9960, that's one of the instances of intuitive language, it's changed from point of collection to point of redemption.
oh, yeah, okay.
And then on page 20, this is probably one of the bigger changes. This is where you have the tiered handling fee. One tier is based on 3.5 cents per container for single feed reverse vending machines. This next tier is 4.5 for all other means of redemption. Or according to a separate compensation agreement negotiated in a redemption location or a group redemption location. So I heard that there was a request for collective bargaining, and that might not be the best term to use. But this would allow for a group to negotiate, a group of them to negotiate what their compensation would be, which I think is the intent of the request.
Want to just check in with a couple of folks here, Mr. Switzer, how do you feel about this portion, particularly? I don't know if you have the draft.
Yeah, I'm looking at it here.
I'm not a lawyer, so I don't know if that covers the intent of what we're trying to do. I'm defer to Mr. Radier. One of the things about to keep in mind about the collective bargaining is that's exactly what they're doing on the other side. And so they're collectively bargaining with us technically, right? So there's been some concerns raised about, well, if collective bargaining is the right thing to do here, that, and antitrust and things like that, but I think we should keep in mind that that's exactly what they're doing on the other side, is collectively bargaining. And they're the biggest companies in the world, so, yeah. That's.
Do you have something to add, Mr. Grady?
No, I mean, it's accurate in one respect, it's not accurate in another, because you create a PRO that is a nonprofit organization that is not on a daily basis, like coordinating with all the manufacturers and distributors that are part of the PRO. But they ultimately are responsible to all of them. It's one of those things that we talked about before, came up with the lighting. They're like, we are all, you know, when you kind of negotiate the 30 lighting manufacturers, so like we're all separately. No, you're not, you're all under the same plan. And so
So
it's existential.
for now,
Okay, that's what.
you know, so we're gonna have to wrap up here soon, but before we go, I wanna go to Senator's back about, the differentiated rates for reverse, single feed reverse.
Single feeder, yeah.
Yeah, versus not, any thoughts about that?
Well. I can't remember from who, but didn't we have some testimony that said it should be the same for both?
Yeah,
I can't remember who gave us that testimony.
there was a report done that showed that
Yeah.
the difference was very small
Like,
between,
yeah.
the single feed
Yeah,
actual costs and manufacturing costs.
yeah, I expected to see the same for both. Well, not basically because anybody told Mr. O'Grady, but you know. I'd be okay with them doing the same. But I'm not, it's not a different difference.
I think. Let's go with it being the same. And I know we have more to talk about on this.
Could I just make right in this section?
Yes.
And it was a point that was made right before I walked in, and I think it's probably a good one. It's in the dispute resolution section, and whether or not. Where's that? So it's bottom of page 20, line 20, consistent with guidelines developed by the Secretary of the PRO, shall use binding dispute resolution to resolve any disputes that arise surrounding fair compensation. That should probably be limited to negotiation of a separate compensation agreement, right? Because you don't want the PRO to come in and say, hey, you need to negotiate with us, and unless you do, we're going to dispute resolution, and we're not paying you the 4.5 cents until we go through dispute resolutions. And it should be probably just limited to separate compensation agreement, or potentially not in there at all.
Interesting. Yes, go ahead.
Hey, going back to page 18, just thinking about this. You know, people are gonna return or not return to the county. Basically. So what if we said, unless the secretary, something like it's including for this year, something like secretary determines that the requirement for immediate certification impediment to efficient, effective. System. So it's some standard. Turn out, I have again, term staff requirement for immediate term, creates an impediment to an effective accomplishment system. There was some standards. Just wait on it.
That makes sense to me. And then regarding this issue that Mr. Grady raised on dispute resolution, happy my sense is to keep it in here, but to limit it as you suggested.
Okay.
Oh,
I'm
yes,
trying to understand what you're limiting it to, just disputes about fair
stuff.
So when you were negotiating a separate compensation agreement, and if you have a dispute underneath that, that would go to bond dispute resolution, but otherwise, the redemption center is going to get more than the compact sense for all of them.
Okay. Okay.
Okay, so with that. Thank you, everybody. You're gonna adjourn for the day. We're gonna pass a bunch of bills tomorrow.